dense presentation, I guess. I wanted it to be pragmatic in a way, and to look at the patentability issue related to fourth industrial revolution. We see, or Industry 4.0 application. We see it's quite broad. I've narrowed it down to some applications of AI, which are indeed at the core. We're going to see it of the current trend, and also the questions related to simulations which have been addressed recently by the enlarged Board of Appeal of the European Patent Office. So basically timely issues, and in fact actually deserved issues to be tackled in that workshop, because speaking from both an institutional perspective, Katerina mentioned I worked for something like 15 years at the European Patent Office, where I was in charge of AI applications, and I saw the dramatic motion towards automation that touches now all fields of technology. So it's not, not just AI, like deep learning, very abstract notions. It's actually everywhere. And from an academic perspective, at the institutions I'm at the moment, at University of Strasbourg, but also at the EUIPO, the doctrinal issues raised by those, the advent of those new artifacts. So actually a nice complementary view that now we have to tackle. And before anything, I mean, just like the requirement of defining the object of protection, a very difficult endeavor in the case of AI and simulations and the fourth industrial revolution at large, for the very reason actually that they're very ill-defined. It's so broad, that touch data management. We've seen that with Thomas a second ago. But also issues of modeling. We're going to talk about it in a second. Optimization, control, user interfaces as well, generative designs. Machines can create in many ways, or can participate in processes of creation. And there are core technologies surrounding those issues, those particular sub-facets, I would say, like software, where algorithms are really at one of the cornerstones of those developments, but also IT developments, sensors, smart applications, smart objects, and connectivity, telecoms, also protocols that participate in sharing data between those objects, and the software applications that are going to try and decipher, analyze, and make sense, basically, of those objects in a vast gamut of applications. I won't be able to cover them all, but there are, of course, applications in the industry, in the healthcare, agriculture in particular, and the telecoms and so forth. So vehicles also are a massive field of development. And it's been sort of realized early on, I mean, at least 10 years ago, at least by the EPO, who drafted authors a series of reports. That's the one from 4 years ago, together with the Ansel-Blatt Research Institute, showing already that between the years 2011, 2016, there was a sort of an observed massive rise of application in the field. Okay, again, very broad field of 4 industrial revolution applications that relate to the facets I mentioned before. But inside that sort of broad trend that was rising quite rapidly, artificial intelligence appeared as a main driver. It's already about 10 years ago. So the numbers show that the applications related to AI, again, a very broad notion, rose by something like 43% annually, with respect to the average rise of 5% for patents overall. So you see the discrepancy between those two different, those particular applications and the average applications, and the average patented applications. So it's been confirmed by a very recent report from December of 2020. Also, but this one focusing mainly on several sub-applications of the Industry 4.0, but basically stating the same facts, that the annual increase of patent families overall is about 4%, but in the field of Industry 4.0, it's close to 15%. And the current fraction of applications that relate to Industry 4.0 is around 10 to 15%, depending on how you define it. Seems massive indeed. So it shows also that there's a sort of a pervasive nature of those applications across the board. And of course, big data, and we've talked about data. Data is, in the context at least of machine learning and AI, is often referred to as the new oil. I think if IP is concerned, it looks more like a minefield data, and IP protection of data, as Thomas mentioned, is not so easy, and then maybe IP is not always the right recourse. But we're going to talk about data with under several angles today, and applications in that broad context of data has shown different routes. One was the rapid use of and development of simulations in patent applications. Again, numbers, just to give you a hint of how fast it's going. In fact, it's exploding. And there's a factor of 10 in the number of applications since 2000, including, the patents related to simulations, with a vast array also of applications, from computer-aided design to data processing, pattern recognition, neural networks participate in that motion as well, and so forth. But at the very core of those simulations, we see also the sort of data-driven machinery embodied by today what we would call AI, but more precisely machine learning. It's been displayed by a recent report by WIPO a couple of years back, examining the rise in patent publication with respect to scientific publications, and showing the sort of the exponential rise of those patents. The arrow between the two could be whether there's a direct link or a sort of a spurious correlation, but indeed we saw that manifestation of rapid increase in a number of publications, be they patent related or academic. So this is quite important indeed, because we see that, and it manifests also in the patent system, of course, in very specific kind of applications like machine learning, which is, as you see here, the real driver of that revolution. And it's an important issue because it touches absolutely, as I mentioned before, all fields of application, from image processing. We know that AI is very efficient at recognizing faces, but not only faces, objects in general now. Speech and natural language processing are becoming also ubiquitous. And of course, controls, fintech, generative design participate in that motion. The reason why we talk about AI today is essentially related to a sort of a paradigm shift. So it's a big word to say that we don't use the same techniques as before. And the one where we were relying on before were based on the identification and the elicitation of rules. So rule-based systems, expert systems, whereby we were basically asking experts to try and identify and word, if they could, the rules that make them work. If you went to a bank teller, how do you assign a credit, allocated credit to someone, for example? It worked fine, actually. Many applications still in use in certain fields, but it's also very limited to a small number of rules, and it can be really easily deployed and modified if anything changes in the world. So the paradigm shift related to instead of asking expert, just look at the data, and using statistical machinery called machine learning, basically optimization. It's a very fancy word for something we've known for a very long time, but now we call it machine learning or AI. We able to analyze large corpora data and examine the data, find correlation in the data, and build basically the equivalent of the rules that were basically enunciated or identified by human beings before. So now we just, human beings, they're everywhere in the loop, and I don't pretend they're absent at all. In fact, they're very much present, but they're elsewhere in the pipeline. And the idea here is that machine learning processes produce something that's equivalent to the rule set that we had before. But now that set of rules is sort of living in a space that only the machine understands truly. I mean, we understand the structure, of course, we control it in a way, but it cannot be easily translated in human language. So it means that it's sort of, that's why we talk often about black box models or model opacity. They live in very high dimensional space, like tens of billions of parameters, which make them very powerful, but also very difficult to decipher. And now that you've built those models, you can deploy them in the field. This model can generalize, or can look at new data and make predictions. For example, finding a category of an object in input data, a face in an image, a value, the probability that there is a particular sound in a given utterance, or even generate new objects. And this poses a series of challenges in terms of IP protection. One of the main reasons is the multifaceted nature of this pipeline. And I'm going to focus on that now just to highlight the difficulty but also the solution in terms of patent protection. Why? Because we talked about data a minute ago, but the learning process, so the statistical learning phase that basically analyzes this data set to produce a model is also composite. There are software and libraries and copyright are involved here, but also algorithm and architecture at the very center of that element. Processes at large, parameters, so other forms of data, but more functional data here. And the model part, we'll come back to that at the end of the talk, that also specific issues related before leading to application. So how do we protect those particular objects? How do we protect AI in simulations? Well, like anything else, basically, we have to go through a set of hurdles that are well identified in the law. First, we have to accommodate all fields of technology. We don't exclude anything. The technology changes, so basically the law has to allow that, sort of accommodate that evolution. But we have to exclude as well certain objects for the reason that they are considered abstract or non-technical. For example, mathematical methods, business methods are considered non-technical, non-tangible, I would say, but the word tangible is not correct, but it's basically abstract entities. So as such, they're not patentable, but if they're basically considered patentable for the reason, at least inventions in principle, you still have to look at the novelty and the inventive step character of the invention. And if you pass all those hurdles, basically you can get a patent, irrespective of the fact I would say that you talk about Industry 4.0, AI, simulation, or whatsoever. Basically, we're looking at a very narrow lens, the particular kind of application that we need to analyze and see whether it fits basically all those criteria. The first one actually is a bit of a fake hurdle, almost, I would say. It exists for good reasons, but it's a very, very shallow requirement. Why do I mean that? Because, in fact, in order to pass that requirement of an invention, of overcome the exclusion of a non-invention, as set out in the Article 52.2 and 3 in combination, we have to have something that manifests technicality. So, for example, if you have a neural network for a simulation, use a neural network to represent your object, your physical object. As such, that neural network is an abstraction. It's mathematical objects, according to the courts, at least at least in the context of the EPO, but it would apply to most jurisdictions. But if you adjoin to that particular object any kind of physical entity, like a sensor, for example, could be a microphone or a camera or just a plain computer, then collectively, basically, it cannot be seen as an abstract entity anymore because of that material object, the sensor or the camera or the computer, and basically you pass already that hurdle. So if you claim something, a neural network with a computer implemented neural network, then basically you pass that first hurdle. So very, very easy hurdle to pass. You see, just add a computer in the claim and that's it. But that's not the end of the game, of course. Now we need to talk, the real meat of that proposition is related to novelty and inventive step in particular. And the issue that is raised by those particular applications where you have a combination of abstract entities excluded as such, like the mathematical object, neural network, and technical entities, like mixed type inventions, is how to basically address the combination of both those facets. So luckily, the good people at the Board of Appeal have addressed these issues, and we now follow basically a sort of a recipe stated in a very well-established methodology in a decision called COMVIC T641/00, and the decision tells us that basically we have to take into account all the components, including the neural network, even if it's as such considered a non-invention, as such sort of a mathematical entity, if it contributes to the technical character of the invention overall. And I'll give you some example in a second. So basically the question, in order to address that sort of compositionality of the technical and non-technical feature is whether the mathematical or simulation method or the steps related to those methods contribute or not to the technical character of the invention. If they do, you need to take them into account and evaluate them with respect to the prior art. If not, you can just disregard them. But that's basically the nexus of the argument. So for AI and machine learning simulations, you have an input, as I mentioned before, it takes data as an input, it outputs some kind of data as well. And in between, there is a computer, I mentioned it was a kind of requirement, that implements a code. It's not the issue of protecting that code here, that implements itself an algorithm based on a model. So there's a sort of like a Russian doll kind of representation of that object. And we are basically going to look at the technical character, the presence of a technical character in that architecture. It's not defined in the positive law. That notion of technicality is not defined. The perimeter of the technical character is not defined either. So we need to look in the case law to try and sort of give a meaning to that notion. That's what we did at the EPO for several years before drafting some guidelines, so the EPO guideline that serves as a sort of a body of soft law to instruct examiners and applicants as to the meaning, basically, of the European Patent Convention. And when we worked on that particular subsection, set of sections related to AI and simulation, we came up with a solution, again, a very simple recipe that sort of frames the boundary of technicality in that context. So how to determine the technical contribution of simulation or artificial intelligence steps? Well, we ask ourselves that particular question in the context of the convict decision. Does this AI or simulation or machine learning method step contribute to the technical character of the invention? And the answer depends only on two independent sub-questions, dimensions. The first one is if it's adapted to a specific technical implementation. And the second one is related to the application to a field of technology. So if your invention lies in that plane somewhere, it can be either due to the application of to a technical field or a specific technical implementation. It can be deemed technical in the sense of at least the EPC, so the case law, the European case law. So what does it mean in practice? So the first dimension, a specific technical implementation, it means something very simple. It means that your algorithm or your simulation is a reflection of the system on which it's constructed. So there's a sort of a yin and yang relationship between the algorithmic object, abstract by nature, but specifically adapted to the core machinery on which it's built. And I'm going to give you an example right now. So if you draft an algorithm and you try and claim that algorithm that reflects the particular nature of a specific implementation, then you may be actually good to go, and that object may be deemed technical. And let me give you just an example of that, and it's an important example because many of the first generation deep learning application rely on that trick, I would say, that recipe, whereby the algorithm was distributing certain calculations towards the CPU, so the common processor on your machine, and others to the graphical processing units, if you had one, to accelerate the process of learning. That algorithm basically was focusing or addressing directly the specificities of the computer it was deployed on. And for that reason, that object was deemed technical. The algorithm, the machine learning process was not an abstraction per se, was not a pure mathematical object, but it was a reflection of the material world. The second dimension is the technical person. This one is a bit technical purpose, a bit more elusive. The case law tells us that, yes, indeed, your algorithm can be deemed technical if it's almost teleologically serves a technical objective, okay? And if this objective is in a field of technology, and if it's well-defined, it has to be specific, then we need to consider that the algorithm has some kind of, by transitivity almost, technical character. So an example here, if you have based on the case law, you have the reference on the slide, is the use of a neural network that can avoid false positive in a defibrillator, so a pacemaker, and there's a detector there that detects basically the chaotic behavior of your heart signal, but you don't want to have an alert every few seconds because you probably would die out of it, out of stress. You want to regulate and avoid false positive signals. And if you create, that's the purpose of the application here, a neural network that basically makes better sense of those signals and avoid unnecessary alarms, then basically you may have a technical application, and the neural network serves that technical application. Okay, so in that case, a neural network was deemed sufficiently well defined and addressing a technically meaningful purpose, so that indeed it gained again by sort of by almost transitivity, as I mentioned, technical character. Another example, you have another kind of neural network, a radial basis function neural network that is specifically constructed to basically control efficiently the working of a turbine, so a wind turbine. And in that case, again, there's a sort of a direct link between the neural network and the technical application. So of course, the space of technical application is very vast, and we're going to talk about that in a moment with simulations. But that we see that at least if the technical purpose is well defined, and if it's deemed technical by the courts, then in fact your neural network can be patentable, or your AI application can be patentable. It's not the case for all applications. Some applications don't pass that basically that bar, but they're very limited in a sense. And for example, the example here of natural language processing that's been recurrently considered non-technical, linguistic in nature, if you will. Business methods, very important in general, if you want to basically phrase or claim an invention in the context of AI and the industry, that you try and avoid that wording that would basically orient it towards business methods. And information retrieval, for example, of the result of ranking the result of a search engine may also be deemed non-technical because it relies on cognitive processes, so basically mental acts. So those actually basically frame the issue of the patentability of AI application in simulation by the negative. There are many, of course, many open questions. I won't spend too much time on the inference models, but in the process of generating knowledge out of this data, the input data, the training data through statistical learning, there are many issues, as Thomas mentioned before, the collection, the scrapping, and of course we have a TDN directive now about that, but and specific treatment of different categories of data by the GDPR. But as for the model that comes out basically of the training process, we relate basically, we sort of fall back on the same situation, same issues that Thomas mentioned before about the fact that those data have been created by the models. So the protection by the sui generis database rights are basically complicated by that fact, and at least with merit discussion. The issue of protecting those models is a very potent one. If you talk about the largest models today that involve millions and millions of dollars of investment, just like to train them, and the very, very big models like GPT-3, you've maybe heard of those models in natural language processing, could they be protected by any IP right at the moment? It's a very complicated issue. There's no straightforward answer to that question. They could be in principle protected by some aspects of patent rights, but writing a claim including 300 billion parameters would make it very long and very boring to read, and also a very shallow protection, because if you randomize just a little bit the parameters, basically you would circumvent the protection. And also because of the hybrid nature of that object, the model is as much an architecture, basically this sort of grid of network of interrelated nodes. Each node is associated with a sort of a matrix or set of parameters, as such as a collection that build something that you could call a database, but that doesn't really fit in the current model of patent protection. So patents actually are not exactly the best tool for the trade. Trade secrets, of course, would work, but we've seen also in the literature recently that those models could be attacked by reverse engineering. So you need to be very careful and take care of your contracts there, but also sui generis database rights are really not working fully for protecting those objects. There could be, I would say, a minor option if your process, so the machine learning process, was protected. by patents. Article 64.2 of the EPC, at least in Europe, we have that tool, could protect the parameters, so the direct products of that patented process. And as such, basically, it's not really a protection in terms of exclusive rights of the models, of the parameters as such, but indeed a probative means to protect the parent training process, really an indirect protection. And if I can finish, I don't know, I didn't look at the time really, so I'm probably finishing now. But
yeah, if you can wrap up.
Sure. Just a word about the simulation question. Recently, the courts and the enlarged Board of Appeals, so it's quite an event. It's not always the case. There are about 3,000 cases treated by the Boards of Appeal per year, and about 3 on average, sent to referred to the enlarged Board of Appeals. So we're very, of course, careful in analyzing those results. And recently, one touched upon computer implemented inventions, in particular simulations, pedestrian simulation, in order to modify or to adapt the design of a building structure. And the referring board considered there was a sort of a discrepancy between their opinion in terms of the lack of direct relationship with the material world of that particular object, a simulation basically to simulate a building, but not necessarily to build that building, and the previous case law that related, called Infineon, I'm just citing it here, that very famous case law that was considering that if you were defining an object precisely enough, and that object was considered technical, the simulation of that particular object was considered technical as well. So the court, basically the referring board, asked the question to the enlarged board, asking several set of questions, and the results were quite interesting indeed, because they gave us guidance now on how to treat those simulations that are very important for Industry 4.0 applications. And they told us basically that they should be treated as any other computer implemented invention. There's not really a particular exception there's no exception at all for the simulation. We follow the COMFIC approach, exactly the same approach as mentioned before, for AI and algorithms. And basically, they tell us something else here, that the technical nature of the simulated object is not a sufficient condition. Indeed, the prediction of parameters, even though they relate to the physical world, are not enough to assign technical character to the simulation. We have to look basically elsewhere. And where do we look? Basically, we look in certain set of options that come up with basically a technical input. If your simulation participate to controlling a sensor, that could basically be considered a technical character to the simulation. Technical output, also controlling a machine, different kind of machine, but it could also produce functional data. So coming back to the question that was raised before, the nature of the data could be functional. It could be functional data that will be later on used to control the technical device. If that's so, if you can demonstrate it in framing in the claim precisely enough, that could also be considered a technical purpose. Adapting, again, same as I mentioned before for AI, adapting your simulation to the platform on which it's working, or vice versa, could also basically connect that simulation to the real world. So there are many ways where basically those models can be deemed technical if they have that further technical effect. That further technical effect basically just connect them to the real world, either through the specific implementation, through the computer, here you have it, or on the left-hand side, or by the application, the specific application, controlling a machine, controlling a sensor, etc. This is important for example, for digital twins, because it's a bit a scenario. I mean, even that diagram, it reflects what a digital twin may be. And in fact, digital twins can be patented. There is actually no issues there in practice. It's another booming field in the world of patents. Predictive maintenance is considered a technical purpose as such. And if a digital twin is realizing such a purpose, well, it can gain technicality, even though it relies on neural networks, on machine learning, or simulation. It's not actually preventing it from being patented if there is that connection through the technical purpose, for example, fault prediction, for example, prevention. But If the application is deemed business related, for example, improving the user satisfaction, then you may not gain sufficient, basically, anchor to the technical world to be deemed technical as such. So it's really an analysis on a case-by-case basis. And okay, that's a very lawyer's kind of answer, but in fact, it's true with those two guidelines here that basically help frame the issue. And just to conclude very quickly, beyond IP, as Thomas mentioned before, we have plenty of IP rights. They're not covering, they're not basically a panacea in all cases. So we need maybe to look beyond IP, also requiring a contextual view of AI simulations and applications. The field of Industry 4.0 is very important to see that context. The broader legal requirements have to be considered relating to the data, for example, but also related to responsibility. And for example, fundamental rights are very important in terms of transparency. I mentioned that at the beginning, those neural networks are not always transparent enough, and that poses very stringent questions of interpretability and responsibility, traceability, basically of the data along that pipeline. So I'm in favor personally of trying to include a notion of auditability by design, almost in defining those models. Patents, they're not, of course, the absolute answer to this auditability, but they can participate because at least one facet of the patent system is to offer transparency through the teaching, actually, of the invention towards the public. So thanks so much. I'm very sorry I probably talked too much, but I had a lot to say.